Please give us a brief introduction. First, tell us your name and your roll number for this exam.
So my name is Ipsita-Aarohan and my roll number for this examination is 300474.
Okay. Now, without telling us your name, please give a brief introduction.
So my name is Ipsita-Aarohan.
Actually, Seti kaun koibe. You don't have to mention your name. You don't have to mention your domicile, like from which district and all you come. Any personal information. Upon the jibe fill up your form as your waiting time there. So they will give you these instructions. Okay. Generally, they are not asking for any kind of introduction. They're directly asking you questions. In case they ask you introduction, so semane pura clearly koithibe ki don't tell your name or any personal information, including district information, etc. So you can start with like, I have your education, start with the education. I've completed my LLB from this. If you want, you can also include 10th, 12th. So that you have to see. Okay. So you can just start again.
So I have studied my 10th in Montfort School, Dhenkanal, and I've completed my +2 in Kuchinda College, which is situated in Kuchinda in Sambalpur district. And I have completed my LLB and LLM from University Law College.
Okay. What are your hobbies that you have mentioned in your CIF?
My hobbies is reading Bibles.
Reading?
Bible.
Reading the Bible. Okay. There is one Old Testament and a New Testament. What is the difference? Can you tell me?
Old Testament is written before arrival of Jesus, and New Testament is after Jesus was born.
Okay. And what are your achievements that you have, special achievements that you have mentioned in your CIF?
Sir, I haven't mentioned any special achievements.
Okay. But special achievement, anything after your standard 7th, anything where you have like, got some award or something that you can mention. Have you ever donated blood?
No, sir.
No. Okay, then. Okay, fine. So, okay, then any other award, prize, anything that you can think about after 7th standard? Because it's if you have something, you should write. Otherwise, you can leave it blank. So you have left it blank. Okay. Give us some good reasons why you're interested to join Odisha Judicial Service.
So Odisha Judicial Service because I want to do good welfare for the people. I believe that by joining judiciary, I can render justice to people, especially those people who don't know anything about law or who have a meager amount of knowledge about law. And I want to serve them, sir. And because of its job security, financial stability, I would like to join OJS.
Okay, about the reasons. So remember, opinion-based questions why you want to join this or what is your opinion regarding something, always use the enumeration method. Okay, my first reason is this, my second reason is this. So that is going to help. You can write it down. Okay, feedback, and you can take that paper. So number 1, in opinion-based questions, answer in points.
Shall I?
Yeah, please write. So in opinion-based questions, answer in points. Okay, enumerate it in points. Okay, right. So, a answer that you practice further because it's a very common question. Why you want to join judicial service? Okay. So this is my first reason, my second reason, my third reason. जिथे आपको reasons अच्छी तब वो warning दे सकते.
So shall I ask something?
हाँ, please ask.
Sir, you have said that special achievements, anything after 7th?
After 7th standard, yeah, for example, you have got a proficiency award in class 5th or something. Generally, we do not mention that. The higher, in the educational level, the better it is. Like the best is university level. Okay.
Sir, I have, sir, I have been awarded many awards for debate competition, essay competition. So.
In which level? School, college?
+2, sir.
Then that you should write.
And I have cleared OJEE and NEET.
Okay.
2012.
So if you had good ranks, then you can also mention that. During law in the law college, moot courts, etc., you had participated, where you got some prize or something.
No, sir.
Okay, then that's fine. You can write one first prize and all what prize you have won in your college level debate competition that you can write. Okay, anything above 7th standard. That is generally we can. Okay, right. So, okay, let us now go to some questions on law. So recently, yesterday, Supreme Court of India has given a judgment regarding rights of women regarding abortion. Have you gone through it?
No, sir.
No. Okay. Coming to procedural law, can you state the difference between res sub judice and res judicata?
Yes, sir. First of all, res sub judice comes under section 10 of CPC, and res judicata comes under section 11 of Civil Procedure Code, and res sub judice bars the subsequent suit which is pending in previous suit, whereas the res judicata bars subsequent suit where the previously instituted suit has been already adjudicated.
Okay. What are the exceptions in which, or what are the circumstances in which a foreign judgment cannot be executed in India?
A foreign judgment cannot be executed in the following grounds, and some of the grounds are having defective jurisdiction, and where the foreign court doesn't recognize any Indian law or on its face it is defective. I'm unable to recall the rest.
Okay. So, is there any provision in the CPC where a civil court can order the arrest of the defendant before the judgment?
Yes, sir.
You can you tell me the order number? If you remember.
Order number 38 of CPC.
Yes, order number 38 of CPC. Correct. So, what is your idea regarding the Constitution? You have good knowledge of the Constitution?
I barely have, sir.
Okay, the basic question I can ask. Article 32, you know?
Article 32, yes, sir.
So it deals with what?
It deals with filing writ petitions in Supreme Court.
How many types of writs are given in the Constitution of India?
5 types of writs.
What are they?
Writ of habeas corpus, certiorari, mandamus,
Okay.
prohibition,
Quo warranto?
quo warranto, and prohibition.
Prohibition, yes. Right. Okay. So, Article 14 deals with what?
1/4.
1/4, yeah.
Article 14 deals with right to equality.
Right to equality. So there are 2 components in it. One is equality before law. One is equal protection of law. What is the difference between these 2 concepts? Equality before law and equal protection of law.
Equality before law means all the individuals are given equal rights, irrespective of caste, creed, race, etc. Equal protection of law. No idea.
Equal protection of law is basically an American concept which basically tells you about that similarly situated people are treated similarly. Okay. So two MLAs will be treated similarly. MLA and a common man. Okay, the MLA will have some privileges over a common man. Okay, that's the American concept. Whereas equality before law, that is basically a British concept, which tells that everyone is equal in front of law, irrespective of whatever. Okay, same law for everyone. Excuse me. So now let us come to some other procedural laws. Law of evidence. What is the concept of res geste?
Sorry, sir.
Res geste.
Res geste. So res geste, the doctrine of res geste deals under Section 6 of the Evidence Act. It states that the acts which come under the acts which are done as a consequence of or in that forms part of same transaction. Though it is not relevant, it's relevant. Though it is not facting issue, still it is relevant.
Okay. Any famous cases that you remember related to it? Res geste?
No, sir, I'm unable to recall.
Okay, R versus Bedingfield, we heard.
Yes, sir. It's
So, in this, what is the meaning of R in this R versus Bedingfield?
R is referred to Queen, sir. Queen versus Bedingfield.
Only Queen. Suppose King is there now.
No idea, sir.
What is that R? It refers to Queen, but the term which is used, R stands for what? What is the word?
No idea, sir.
So just go through that part. Okay. Right. So let me suppose a witness has turned hostile. Whatever evidence the witness has given, should it be thrown out, or some part of the evidence that the hostile witness has given can be used?
Yes, sir. When the evidence turns hostile, especially if talking about an accomplice, that any witness if turned hostile, the statement can be used in favor. The prosecution may use it. Suppose a prosecution witness if turns hostile, then the statement could not be relied on. Sometimes it could be corroborated with other evidence in case it is taken into consideration.
Okay, fine. So, what is the evidentiary value of hearsay evidence, and what are the exceptions to it?
Hearsay evidence is an evidence which is given by a person who himself has not witnessed it, but who have heard from someone else, and he is giving as evidence. This is called hearsay evidence. And hearsay evidence normally could not be given in court. It is not admissible in court. Still, some of the exceptions are doctrine of res geste, or when or as a dying declaration. Or when the contents of a document is given orally, when the document itself is not available, or when the genuineness of a document is in question, then it may be admissible, sir.
Okay. So now coming to CRPC, what are the stages in a criminal trial?
There are 4 stages. First is intention. Second is preparation. Third is attempt, and fourth is commission.
That is, you're talking about a crime.
Crime.
I'm saying criminal trial.
Oh, sorry.
Stages of a trial.
Trial.
Like in a criminal trial, what will happen first? Then what happens? Charges are framed, or okay, finally what happens?
So normally, sir. Or in
there are certain specific stages. Yes.
Sir, first of all, either complaint is filed, police report. In case of information received, then there is a police report, sir. Then the magistrate shall shall summon the defendant to appear before it. And when the defendant appears or the accused appears, the prosecution starts its case by introducing certain facts and by what evidences it relies on. And the court shall hear both the sides. And if the court thinks that charge should not be framed, then it shall discharge the accused. And if it thinks that the accused has committed some offense, then it shall proceed in framing a charge. After framing a charge, it shall be read over to the and explained to the accused. And when and ask if the accused is plead guilty or not. If the accused pleads guilty, then it proceeds. Then it convicts the accused, and when accused does not plead guilty, the court proceeds to trial. And further, the court gives someone on application of prosecution. The court gives some issues summon for witness appearance and for the production of document, and it examines all of them and hears the defense of the accused. And after that, the accused enters into defense, and when he gives application, the court summons the witnesses and production of documents from accused side. And after argument, entering into argument and examination, if the court finds the accused guilty, then the court convicts it. And if the court does not find him guilty, then he discharges him.
Okay. So, under the Indian Penal Code, can you tell me what is unlawful assembly and what are the intentions? Okay, if that intention is there, then only we can say that it is an unlawful assembly.
Unlawful assembly is when 4 or 5 people gather together in furtherance of common intention that they would breach, they would do an act which causes breach in public tranquility or public peace.
Okay. And it is dealt in which section of the IPC? That's fine. Section you need not remember. What do you mean by trifling act, and what are the penal provisions for trifling acts?
Sir, tribal acts.
Trivial acts, if you can say.
Sir, can you repeat the question, please?
Trifling acts. Okay, what is the meaning of a trifling act under IPC? And what is the penal provision in case of a trifling act?
Trifling act, I don't have any idea.
Yeah, it is like what you're saying, like a trivial act. There's another term for that.
Travel Act comes under general exception, and any petty issues, any act relating to any petty issues.
What are the penal provisions for that? Will the court, give some kind of penalty? Okay. What are the types of, punishments under the IPC? How many types are given?
Around five or six types.
5 or 6. Okay, you can just say.
So,
Another thing is when you are, don't be in a dilemma. Don't say 5 or 6. You're very sure it is 5, say 5. If you're very sure it's 6, say 6. Okay, if you're not sure, then just name whatever you can name, 3 or 4, whatever you can name. Okay. So don't give any answer with some alternative, 5 or 6.
yes.
Okay. You're sure about this? Yes. Okay. So please continue then.
So there are 5 types of punishments: simple imprisonment, rigorous imprisonment, forfeiture, fine or penalty, and death, sentence of death.
Okay. So what are the ingredients of the rarest of the rare doctrine which the Supreme Court has given for death penalty? What if these conditions are fulfilled, then that case will go under rarest of rare.
Sir, the person should have committed any act which is injurious or causing harm to the aggrieved person or the victim. And even if there are devices to save, there are facilities that after the injury he might be saved, but still he would be convicted, sir. Yes, I am unable to.
Okay. We'll just go through these provisions. Okay, so that will be the end of the interview. Overall, so you can take down the feedback. Eye contact was good, but it was not 100%. So you try for 100% eye contact. Okay. But eye rolling was not there. So it is more or less it is okay, but 100% eye contact is needed in the actual interview. Okay. Smile was maintained. So like you are not very serious. There was smile. So maintain the smile. Even if you're unable to answer something, maintain the smile. Okay. Then number 3, no guessing, no bluffing. Okay, and if you're not sure about something, don't give that answer. That I think that would otherwise content and all is fine. Okay. So just remember that if you do not know the answer or you are not very sure, okay, like you said, there are 5 or 6 types of punishment as well. Don't give that kind of statement. When you're very sure, you tell them that. Okay. So rest other things are fine. Okay.
So can I